Let's bring in our guest to discuss this. Joining us in Fort Lauderdale, Florida, criminal defense attorney, friend of the program, Eric Schwartzreich. I almost lost my words there. It was just so emotional. You can hear her catching her breath, facing her sister's convicted killer. Talk to me about the planning and how do you, in the court setting, help a young lady like this prepare for such a big day?
Matt, happy Friday. Thank you for having me. Fortunately, it's a sad Friday, especially in this courtroom. And we're here at this sentencing hearing where it's not about what happened because the jury determined what happened. It's about what happens next. So we have this sentencing hearing where it's about justice. It's about accountability. It's about, making someone accountable for their actions. It's about protecting society. And what we have here is the sister testifying, a victim impact statement where it's kind of cathartic for her, where she's coming in the court and speaking on behalf of her sister, getting to look the accused, the defendant, now the convicted in the eyes. Nothing is going to bring back her sister. She's young, she's brave, not an easy job that this prosecutor had to do to prepare her to come in the court, but she did a really, really good job. And what the judge is going to do is weigh those statements and listen to the victim impact statements from the three family members or witnesses that are going to testify on behalf of the victim to determine what is the appropriate sentence. Is it going to be life in prison because the judge's hands are tied on the conviction and can give more with consecutive sentences, or is there going to be a possibility of parole for the defendant in this case? And
there was a lot of evidence in this case against this guy. The jury of 12 convicted him, but he has maintained his innocence. So as from the defense point of view, it's always the defendant's right to give a statement in allocution. Do you think that we'll see one of remorse or anything like that from him? I'm hearing that he's going to speak.
I think if he speaks, he needs to be remorseful for what he is facing in the sentence to get the possibility of parole, which I don't think this judge is going to do in a case like this. But he has maintained his innocence. He decided to exercise his Fifth Amendment right. He didn't testify at this trial. From what I've read, from what I've seen, he's always maintained his innocence. This was a circumstantial evidence. You might not see the wind, but you'd be foolish not to know that the leaves are blowing around because there is wind there. This defendant has not seemed to have accepted any responsibility. He has indicated that he went to trial. He says he's innocent. I believe he's going to say that. I believe he's going to stay silent, or if he gives some statement, say that he feels sorry for the victim's family, but I'm going to exercise my right to appeal. If he does do that, in my opinion, it would be wise to just have his lawyer make a statement on his behalf and say, because of appeal, I've advised him not to speak. I don't think it's going to be a good look in front of this judge to make a denial. If he does that and say, I'm going to appeal this case, it's probably better off not saying anything. And I don't expect that he's going to admit to his actions based upon following this trial.
Well, we'll watch together. Eric, thank you. You're going to be sticking with us all hour long.